There will be no changes to the terms of reference of the inquiry probing the fitness of Gauteng prosecutions boss, Advocate Andrew Chauke, to hold office. NPA head Shamila Batohi had applied for the terms to be amended, arguing that the document signed by President Cyril Ramaphosa differed from the one she had submitted. Batohi, who's the lead complainant against Chauke, walked out of Monday's proceedings, saying she wanted to consult with the legal counsel. Security expert Eldred de Klerk joins us now to discuss the matter further. Mr. de Klerk, good to have you on the program this evening. So from a security and governance perspective, how serious is it when the head of the prosecutions authority walks out of a formal inquiry while still under oath?
Good evening, and good evening to your viewers. It's an important question, and essentially it is of grave concern. There is no issue in and of itself when you have a break in testimony, because she's been testifying for 2 weeks and she's always under oath, which means do not discuss it with others, don't collude with others, to ensure that your testimony is unadulterated and it's your own testimony at your own account. When you then decide to stop testifying 2 weeks in and then say, this is not what I signed up for, nor what I asked, that is a concern, because you knew coming into this that this is the scope and the brief of the commission. You knew you're going to have to answer a range of questions, or you could have foreseen you're going to be asked a range of questions, and you have to provide evidence on the given brief. So for her then, it was fine to say, look, this is not what I signed up for. I'm asking permission. Let me consider, and I'll come back to you. Is there any room and scope? The way she did it was, in a word of the commissioners and the evidence leaders themselves, disrespectful, because she took it upon herself to excuse herself. And as an officer of the court, she needs to know there's both decorum and respect that's afforded the officer of the court, and she should have embraced that and be an exemplified, or an exemplary example of that decorum and respect.
But what risk does this kind of conduct then pose to the credibility or even the authority of institutions that are tasked with upholding the rule of law?
Well, essentially, if they don't act against her, and she continues to show this kind of disrespect, she can obviously be called, she can be charged with contempt of court. The issue is more that her own credibility is brought into question, and her testimony and the decision to even call for this inquiry is then brought into question, because it seems that she had a theory and she made that theory fit a sequence of, she made the theory drive the evidence rather than the evidence drive what should have been the inquiry. So, and suspicion in of itself as to your colleague, so to act against a colleague is a big deal. To then call for an inquiry against a colleague is just as big a deal, because that's not often done. But then you can't say, I now want my evidence to fit the facts, so to speak.
Yeah.
So it's more likely that her credibility will be called into question rather than the credibility of the commission itself.
But also interesting for me is that Batohi cites concerns about her integrity and the nature of the questioning she's heard. In high-stakes inquiries like this, where should the line then be drawn between protecting personal rights and also respecting institutional process?
Well, yes, of course. Anything that either impugns your dignity, or impugns your character, or could incriminate you, those things you are at liberty to say, I will not answer them, or I will not address that particular question. That you can do, no problem. If it's a reasonable question to which she reasonably can be expected to answer, or to have an answer or have a reply, she's under oath and obligation to look to answer that question the best she can. And she can do that and she should do that without lying, because lies will be caught out later. If she cannot answer the question, she will simply say, I cannot answer that question and I would rather not speculate. And that is because you never know, as much as you prepare, where evidence will go or where one question will lead. So stick to your script, answer what you can, say you can't answer certain things, and that should be enough.
But how does this incident then affect public confidence, especially in the NPA, especially also in cases involving senior officials and alleged abuses of power? I mean, this all comes as everybody's watching because these proceedings are being broadcast as well.
Absolutely, and what we've seen both at the Madlanga Commission, the Ad hoc Commission, and now at the Nkabinde Commission is that we see senior public officials not being able to reasonably answer questions put to them, nor actually justify decisions that they made. And that is very worrisome because we would hope to say that that cannot be an example of all public officials, and it's not. Nor is it the particular characters involved in these commissions or these inquiries. So it more says about the process of appointment, and we are going through a process of appointing a new head at the moment, but it also says something about how often the decisions, the behavior of these heads of departments are under scrutiny. How robust is the oversight over their decisions and over their departments and over their offices so that they are not surprised when they have to come to the occasional commission or the occasional inquiry. We need Parliament, we need the Judicial Commission, we need the Chief Justice and others to ensure that their decisions, if it's up for review, should be periodically reviewed. They should periodically be assessed. There should be assessors who do so to help them make the best decisions possible so that they are not found flat-footed and tongue-tied when it comes to an inquiry such as this.
From your experience, Eldred, how critical is uninterrupted cross-examination, especially also in cases involving allegations of intimidation, misconduct, or abuse of authority like we're hearing? Of course, we did hear from the counsel for Mr. Chauke, that's Nkabinde, who raised his apprehension or his dismay at Batohi's conduct.
Well, as a state prosecutor, she should know that you would like a case to be uninterrupted. You would like the entirety of the main body of evidence being put and then deposed. When you have constant breaks in evidence, witness testimonies are likely to change, it's likely to be inconsistent. If they're not properly briefed, if there's not an affidavit from which they speak in, if they have memory recall, our memories change, it fades, detail is lost. And what you would like to see is an uninterrupted, as you say, witness providing a testimony to which then can be deposed. That is good for the witness because they sit down once and they say what they want to say. It's good for the defendant because the defendant can hear the entirety of the main body of evidence and they can prepare their case based on that. Constant disruptions, long delays actually can harm or hinder both the case or the defense's opportunity to prevail when it comes to a particular case.
Eldred de Klerk, thank you so much for your insights. Really what unfolded at the Nkabinde Inquiry goes beyond one individual or a case. It would strike at the heart of accountability, institutional integrity, but also public trust in South Africa's justice system. As this inquiry continues next year, the implications of leadership conduct unchecked, authority, or even procedural breakdowns will be closely watched, not just by legal expert or security experts like Eldred, but by public demanding transparency and fairness. We will continue watching the story very closely, bringing you developments as they unfold.